Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner. And on behalf of Judge Bennett and Judge McBrayer, we welcome counsel to this oral argument, which we are live streaming in order to fulfill our obligation to maintain our open courts. We will conduct the hearing in the same manner as if we were all in the courtroom together. The appellant and the appellees have 15 minutes per side to argue. I understand the appellant has reserved 2 minutes for rebuttal, and I understand that the appellees are dividing their time with Mr. Busey taking 9 minutes and Mr. Belcher with 6, and the clock will be programmed accordingly. Unless there are any announcements, I will ask Mr. Hibner to call the case.
Martin Holmes et al. Versus David Karkau et al.
All right, we'll hear from the appellant.
Thank you, Your Honor. Good morning. May it please the court, Martin Holmes on behalf of the plaintiffs and appellates. By way of introduction, the clear and express purpose of the Tennessee Uniform Fraudulent Transfer Act, herein we'll refer to as the TUFTA, is to prevent fraudulent transfers to avoid creditors. And if ever there was a situation to which the TUFTA should apply, it is this case. The facts are really not in dispute. Wendy Karkau and her now deceased husband, Kenneth Karkau, sold their home to Mr. and Ms. Holmes on April 4, 2013. The Holmes is alleged that the house had numerous undisclosed problems, resulting in hundreds of thousands of dollars in repairs. In early 2014, the Holmeses filed suit against the Karkaus, and during the pendency of the lawsuit, almost 2 years into its initiation, Mr. Karkau died on or about December 8, 2015. The day before his death, Wendy Karkau transferred the $500,000 beneficiary interest in Kenneth Karkau's life insurance policy from her as the beneficiary to their 2 children, David Karkau and Shea Baird, who are also defendants in this action. It's undisputed that had the transfer not occurred, Ms. Karkau would have been the beneficiary of $500,000 as of December 8, 2015, and that those monies would be subject to execution should the Holmeses obtain a judgment against her in the underlying action. Now the appellees seek the assistance of this court to aid and condone this nefarious conduct by ruling that the transfer of the beneficiary interest is not covered under the TUFTA. Based on the foregoing, we are respectfully requesting that the court reverse the trial court's order granting the appellee's motions and rule that appellants have stated a timely claim for which relief can be granted under the TUFTA. We have 3 arguments. First, that the trial court erred in holding that the beneficiary interest transfer from the wife to children was excluded under the TUFTA by virtue of TCA 567203. Second, the trial court correctly held that a beneficiary interest in a life insurance policy can be an asset under the TUFTA. And third, the trial court correctly ruled that the appellant's claims are not time barred. First, the trial court respectfully erred in holding that the beneficiary interest from the wife to children was excluded under the TUFTA by 567203. The court correctly held that, in general, a party can bring a cause of action under the TUFTA as a result of a transfer of a beneficiary interest. The plain terms of the statute, a beneficiary interest qualifies as an interest and an asset. The asset is the life insurance policy because it is subject to ownership. But despite holding that the beneficiary interest can be an asset covered under the TUFTA, the trial court ruled that in this action, regardless of whether her beneficiary interest was an asset or an interest in the assets, the appellants could not state a claim because under TCA 66-302, an asset does not include property to the extent that is generally exempt under non-bankruptcy law. And then held that under 56-7-203 that it was excluded. First, as an initial matter, the TUFTA broadly defines asset. Under 66-3-3022, asset means the property of the indebtor, but does not include 3 narrow exclusions. 1, property to the extent that it's encumbered by a valid lien. 2, property to the extent that it is generally exempt under non-bankruptcy law, or C, an interest in property held in tenancy by the entireties to the extent that it is not subject to process by creditors holding a claim against one tenant. It's our position.
Mr. Holmes, has
Yes.
Tennessee courts ever said that a beneficiary interest is property?
Well, what they have held, I know in the case of N. Ray Olean that we had cited, the court was interpreting TCA 56-7-203 and held in that case, N. Ray Olean, the courts said that there was an exemption in bankruptcy for the holder of the life insurance policy, but not the beneficiary. So I think in those cases, they have determined that the beneficiary interest was an asset and subject to the control of the bankruptcy estate for the.
I mean, but it strikes me that it's somewhat different saying that an interest is subject to the bankruptcy estate or part of the bankruptcy estate, and then calling it property. I mean, it seems like to me there's a legal distinction there. I'm interested to know if there is a Tennessee state law case that says an interest of a beneficiary in a life insurance policy is property.
Unless I'm not aware of that, I do know that based on the Tennessee Viatical Settlement Act statute, that it covers an interest. It defines a viatical settlement purchase agreement that is defined as a contract or agreement entered into by a viatical settlement purchaser to purchase a life insurance policy or an interest in a life insurance policy. And so it's our position then that the ability to purchase an interest in a life insurance policy would be an asset and subject to the Tennessee Fraudulent Transfer Act. Did I answer your question?
Well, I think the answer is no. There's not a Tennessee case that holds that. But I appreciate the information on the Viatical Settlement Act.
Yes, and I think that by virtue of the statute, that implicitly would mean that it would be an asset, and I think for the intent and purposes of the TUFTA, the court should broadly define what is an asset, and there's only 3 narrow exceptions to that, and that I just enumerated a minute ago, and it's very interesting that the Tennessee legislature did not indicate that it did not include property to the extent generally exempt under bankruptcy law, and the appellees rely heavily on bankruptcy cases, and it's our position that had the legislature intended the TUFTA to exclude property generally exempt under bankruptcy law, that it would have included that, and by not including it, it's excluded.
Let me ask you one other question about the facts here. You indicated in the opening you thought the facts here were largely undisputed, and I agree with that, but it seems like there's one potential loose end here, and I'm wondering if it matters or not. Was the decedent competent at the time that the transfer of or the change in the beneficiary and life insurance policy? I take it that's an open issue, an open factual question.
That is an open factual question according to the appellees. I think that looking at the complaint as pled and liberally construed and with the facts, that Mr. Karkau was incompetent. If Mr. Karkau had been competent, then Ms. Karkau would not have used the power of attorney. And that suggests that, and he was this literally occurred the day before his death when he was in the advanced stages of Alzheimer's disease. So it's reasonable from those facts to infer that he was incapable of making decisions. a hypothetical, assuming this lawsuit, the underlying lawsuit, was not pending, and so there was no pending claims against the Karkaus, and Mr. Karkau had, the day before his death, transferred the beneficiary interest. Wendy Karkau would have been the first one to challenge that and argue that he was incompetent. So I think the facts, as liberally pled in the complaint, certainly strongly suggest that he was incompetent, and through the discovery, we're confident that it will prove that that he was not competent at that point, which and including the fact that she used the power of attorney. I think that in my limited time, I had talked about it in our brief outlines, why we contend that 56-7-203 does not apply to this situation. And in our brief, we recited the cases of Enright Olean, Macklemore, and LaForest. And in those cases, they made the clear distinction between, in the language of 56-7-203, it states the net amount payable under any policy of life insurance or any annuity contract upon the life of any person made for the benefit or assigned to the spouse and or children or dependents dependent relatives of the person shall be exempt from all claims of the creditor of the person. And what's important in that is that in these cases make the distinction that the 203 is limited to the person, meaning the owner of the life insurance policy. So it's true that, for example, had Mr. Karkau remained living and the Holmeses obtained a judgment, they could not execute on the beneficiary interest of that policy. But the distinction, and they made in the cases that I've just cited, is the courts have said that the person means the owner of the policy, not the beneficiary, and the beneficiary just cannot use 56-7-203 to exempt that as property. The last thing I want to cover very, very briefly is on the argument that the claim is barred as a matter of law. As a threshold, whether the appellants filed their Tufte claim with 1 year of the time when the fraudulent transfer was or could reasonably been discovered is a question of fact or fact for the fact finders, unless reasonable minds could not differ about the conclusions from that could be drawn from the facts. Even the appellees, David and Wendy Karkau, acknowledged that at this stage, at the pleading stage, that determination is premature, and it would be more appropriate for a motion for summary judgment after the facts have been developed. But from the facts that are pled in the lawsuit, they do not establish that the claims are time barred as a matter of law. Granted, there were some suspicions that there was a life insurance policy, that Ms. Karkau may have been the beneficiary, but there was no proof that there was a beneficiary interest that had been transferred. And if the court will review the facts that are in our brief, it clearly lays that out, even at the hearing before Judge Martin in Williams County, Tennessee. Ms. Karkau did not indicate that there had been a change of beneficiary interest. Her attorney didn't. It was clearly left as being speculative. Judge Martin saw that as being speculative. It was only after that it was ascertained that the transfer of beneficiary interest had occurred by subpoenaing the records from West Coast Life. And at that point, the plaintiffs filed the lawsuit in this action within 1 year. Thank you.
All right. Thank you, Mr. Holmes. You'll have time for rebuttal. We'll now hear from the appellees.
Okay, you're gonna unmute me.
You're unmuted.
Okay. Thank you, Your Honor. This is Ray Busey on behalf of Wendy Karkau. In this case, the plaintiffs cannot make the most basic fundamental showing required to proceed under the Tufte. As a matter of law, they cannot show that in changing the beneficiary designation, either Kenneth, as the owner of the policy, or Wendy as the originally named beneficiary made or suffered the transfer of a valuable asset of his or hers that the plaintiffs could have executed on to satisfy their claims if they are ever reduced to judgment. And I'll just mention in passing that this underlying lawsuit about the condition of the house has been pending more than 8 years and is not at this time set for trial. As Wendy's brief demonstrates, even if the plaintiffs had gotten final enforceable judgments against Wendy and Kenneth and had gotten executions served as of, say, December 1, 2015, it would have availed them nothing. Kenneth's interests in the policy were absolutely exempt from the claims of his creditors under TCA section 56.7203. Wendy's expectancy was not reachable by such process. She had no interest in property to which the execution could attach. The nature of an expectancy is too ephemeral for an execution to glom onto.
Well, Mr. Busey, I want to ask you about that, and it goes into my question about the competency of the decedent here. It seems like to me we've got a really unusual set of facts where, I'd agree with you that typically a beneficiary interest is an expectancy, but if the decedent was incompetent, it really became more than an expectancy based on the durable power of attorney, because then the widow was the only person that could have affected that interest. And to me, it becomes a surety there if the decedent is incompetent. So I wonder if this case has to go back to determine the outcome of that question.
I don't think so, Your Honor, for several reasons. Number one, of course, as Mr. Holmes said in response to a question, if Kenneth had been competent at the moment that the transfer or the change was done, the power of attorney would not be used. I mean, if he were literally able to do that, it wouldn't be appropriate for her to use the power of attorney. But the next thing I would say is that the plaintiffs know absolutely nothing about the condition, the mental or physical condition of Kenneth Karkau in the period from the time that he was diagnosed with Alzheimer's in 2011 and the day he died. All they know and all they have alleged in the complaint is that he died on December the 9th, 2015, as a result of complications of Alzheimer's. They know nothing else about his physical or mental condition. But more importantly, the notion that Wendy could do with the policy whatever she pleased if he were incompetent and she had the power of attorney is just not consistent with the law of agency. There are reported decisions in this case where actions of an attorney in fact or agent have been set aside because they were found to have violated the agent's duties to her principal. But the plaintiff's complaint does not allege that in taking the action she did, that she was acting contrary to Kenneth's wishes, as she reasonably understood them, or against Kenneth's best interest. There's no allegation that she breached her fiduciaries to Kenneth in the exercise of the power of attorney. Furthermore, I would note that after Kenneth's death, when the application was made to the insurance company for payment of the death benefit, the insurance company had before it all the relevant documents, including the change of beneficiary forms, the powers of attorney, Kenneth's death certificate. The insurance company did not see any defect or irregularity or ambiguity in the documents before it, and accordingly paid the death benefit in accordance with the December 2015 change of beneficiary. 5 years after the insurance company paid out the death benefits. The plaintiffs brought this case asking the court to disregard the insurance company's interpretation of its own contract and the documents that were presented to it, and to recharacterize that transaction as the transfer of a beneficiary interest. Beneficiary interest is a term that the plaintiffs have coined. You won't find it in any statute or case that I have looked at. It's a coined term of the plaintiffs. But they're basically saying that even though the insurance company looked at all these documents and they were clear and unambiguous to them, the power of attorney, the change of beneficiary, they want you to recharacterize that transaction. So I just don't
Mr. Busey, you refer to this as or you say they do as a transfer of a beneficiary interest, but isn't it a change of beneficiary as opposed to a transfer of a beneficiary interest?
It is. That's what it is. It's a change of beneficiary. And it is deemed to be the act and deed of the owner of the policy, Kenneth. Kenneth, acting through his duly appointed power attorney, in fact, changed the beneficiary. And the insurance company looked at the form and said, well, that's what it is. If the insurance company had looked at that form and said, you know, this is a kind of a strange thing. This looks like the beneficiary has attempted to transfer her beneficiary interest. If that's what the insurance company had thought when they looked at that document, we would have a very different case. The insurance company would probably have filed an interpleader and named all of the primary and secondary beneficiaries as defendants, and we would have been off. It would have been this case would have unfolded in a completely different way. But the documents that were there before the insurance company were clear and unambiguous, and they interpreted them in accordance with their contract. And after all,
but the legality and the appropriateness of the change of the beneficiary is really not what's at issue here. I mean, to me, this situation is somewhat unique from every other case in that the beneficiary that would originally have received the funds had the power to change it. And it seems like you're conceding that maybe there was an incompetency here, because otherwise she would not have taken the action under the durable power of attorney. So, I mean, that really becomes more than an expectancy there. She had full control over changing the beneficiary or not changing the beneficiary. I mean, that somewhat distinguishes this factual pattern from every other change of beneficiary case we've seen.
But Your Honor, she had fiduciary duties to Kenneth to act in his best interest and to act in accordance with his wishes. She was not free to do anything that she pleased. And so I think that is the important fact there, is that there is no allegation in the complaint that she was breaching her fiduciary duties or acting contrary to Kenneth's wishes when she did what she did. And, you know, it might be a different case if the original beneficiaries had been the children and she had changed it to make herself the primary beneficiary. But the direction of her action was in the opposite direction.
All right. Thank you, Mr. Busey. We'll now hear from Mr. Belcher.
Morning, may it please the court. John Belcher for the appellees, David Karkau and Shea Karkau Baird, who were the children in this case. We respectfully request that the trial court's dismissal of the complaint be affirmed. Not only was the trial court correct in its rationale for dismissing the complaint, but we contend there are additional grounds as well that would warrant dismissal. My clients will ride on Mr. Busey's coattails and adopt those arguments that he's presented regarding the question of whether beneficiary status is an asset under the Fraudulent Transfer Act. We agree that it is not. It's a mere expectancy. Furthermore, it's exempt under TCA 567203. I'll detour real quickly to the question that was just being discussed. We would point out that everything that Wendy did pursuant to her power of attorney, Kenneth Karkau could have done himself, and there would be no claim for it. He had the right to change his policy at any time, and changing it to his children would certainly have been within his right, and he could have changed it again thereafter the next day if he chose to. Factually, my clients are one step further removed from this case than even Mr. Busey's client. David Karkau and Shea Karkau Bear have never had any role in the underlying litigation. They're not parties to that case. They had nothing to do with the sale of the house. All they did is they received a life insurance payment when their father died in 2015, and that's the extent of their connection to the plaintiffs in this case. They are, we would respectfully contend, precisely the category of individuals that are protected by 567203. The plaintiff, in other words, was never their creditor. They are the children beneficiaries of their father's life insurance policy. Kenneth Karkau, as I just alluded to, had the right to change that beneficiary at any time. And the implication of the plaintiff's argument is that anytime a policyholder wants to change their beneficiary, they would first have to look at their existing beneficiary's financial statement, determine whether there are any creditors or claims or insolvencies or liabilities or potential liabilities, and then keep that policy in full force and effect for their beneficiary's creditors. And we respectfully contend that that's not the law, that an owner of a policy can change it at any time for any reason, and that the beneficiary does not own any interest. And there is the Tennessee law, we believe, is clear on that it's a mere expectancy, and we're not aware of any law in Tennessee to the contrary. Now, in addition to those issues, my clients have raised an additional grounds that we argued at the trial court, and that is that the claim is barred by the statute of limitations. And that is admittedly an unusual argument for a motion to dismiss. It might more often be seen in a motion for summary judgment. But we believe it's appropriate here given the extremely specific allegations in the complaint and the large number of exhibits attached to the complaint and incorporated therein. It's undisputed that the plaintiffs had 1 year to file this action from the date of the transfer or the date that they could reasonably have discovered the transfer. And that's really what we're traveling under here, that inquiry notice. More than 1 year before they filed the complaint itself states on its four corners that the plaintiffs were actively investigating the life insurance issue. They were sending subpoenas for bank records. They were sending subpoenas to the insurance company. They obtained a court order to do their investigation of the insurance company. They were representing to the court that they believed Wendy Karkau to the beneficiary. They were told in court that Wendy Karkau did not receive the proceeds. They articulated their concerns regarding a potential change of beneficiary. And we've walked through all that in our brief. And looking at the statute, that we would contend is the very definition of inquiry notice. And the Supreme Court in the Red Wing case said that inquiry notice charges a plaintiff with knowledge of those facts that a reasonable investigation would have disclosed. Once a plaintiff gains information sufficient to alert a reasonable person of the need to investigate the injury, the limitation period begins to run. Here, more than a year before they filed the case, the plaintiff stated in open court and pled this as a part of their complaint. It's attached to their complaint that, quote, there's strong circumstantial evidence here, Your Honor, that this West Coast Life policy, that Wendy Karkau was the beneficiary of the policy. I'll skip forward a little bit. The phone records we subpoenaed and obtained and that they tried to block show she made phone calls to West Coast Life in the days leading up to the death. There's strong evidence that Wendy Karkau may be the beneficiary and being untruthful. If there was a change of beneficiary, obviously during the pendency of the lawsuit, then those assets are arguably being fraudulently conveyed and would go to her net worth.
And when were these statements made?
More than 1 year before they filed the complaint in July of 2019, and that transcript is attached to the complaint and incorporated therein pursuant to Tennessee Rules of Civil Procedure 10.03, and we've cited the Pagliara case for that as well. By
And
choosing,
Mr. Belcher, you're saying that these statements were made in the other lawsuit, the suit regarding the house.
that's correct, Your Honor. The complaint goes in detail through the underlying litigation step by step and attaches the transcripts. This complaint attaches the transcripts from the underlying case, showing that all of these suspicions were raised in the underlying case more than a year before this case was filed. And therefore, we believe on the four corners, this complaint is barred, taking all allegations as true and in a light most favorable to the plaintiffs. They've pled that they knew about this more than a year before they filed this case.
Thank you, Mr. Belcher. We'll hear rebuttal from Mr. Holmes.
Thank you, Your Honor. Just to clear up a few things, Mr. Busey said that plaintiffs know absolutely nothing about Mr. Karkau's medical condition. That's incorrect. With respect to Mr. Busey and Mr. Belcher, they are not involved in the underlying action. There has been extensive discovery regarding his medical condition. His medical records have been subpoenaed and obtained. None near the time of his death, but all indicating that he was suffering from advanced stages of Alzheimer's and declining health and was not competent. And we fully expect that will be borne out in the discovery in this case if it were to move forward. And then also it begs the question, why did Ms. Karkau use the power of attorney? In terms of the issue on the statute of limitations, the facts are laid out in the briefs and in the record. Ms. Karkau was untruthful about knowing about a life insurance policy. It was determined that she had she knew something about a life insurance policy by subpoenaing her bank records showing monthly payments taken out. We attempted to block the subpoena for West Coast Life, and you can read it in the transcripts. There's nothing in the transcript from the hearing before the court that would indicate that we knew that there had been a change of beneficiary. And of course, it could have been cleared up by Ms. Karkau or her attorney being candid to the court, and they were not. They didn't disclose that there had been a change of beneficiary. The Red Wing case cited by the appellees held that it is a question of fact on this issue. So based on that, it's our position that at best this is premature, and that just based on the complaint, it was pled and filed within 1 year of obtaining knowledge of the transfer.
Thank you, Mr. Holmes and Mr. Busey and Mr. Belcher. You've given us a lot to think about. We will take this matter under advisement. Mr. Hivner.
This honorable court is now in recess until 10 a.m.